Good morning. Happy Sunday. I've had a lot of people talk to me about Travis Heinze, and James Freeman recently did a video on a Travis Heinze encounter with the Cache County Sheriff from 2016. How do we know it was from 2016? Well, this is the original video, and you can see it was from October 12th of 2016. Now, James Freeman believes that the Cache County Sheriff did not have reasonable suspicion to demand Travis Heinze identify himself. And I find that to be rather odd. It's not unlike James Freeman. See, James Freeman thinks that just because Travis Heinze is demanding to know what crime that they have reasonable suspicion that he's committing or whatever, just because they're not answering that question, well, James Freeman doesn't think they've answered that question, but just because the person who's hearing it doesn't believe that they've answered that question, that they must not have reasonable suspicion. And reasonable suspicion is, again, one of those things that, first of all, it's very easy to develop. It's very easy to develop. Again, just see Illinois v. Wardlow or Terry v. Ohio. I mean, it's a ridiculously low bar for the officer to hurdle. But in this case, it's even easier than that. Now, what does an officer need to be able to demand ID? James Freeman, for some reason, puts the 2019 statute for the authority of a peace officer to demand ID. I don't know why, because again, the video was taken in 2016. Now, the 2016 version is very similar to the 2019 version, except there are a few minor changes. Number one, instead of saying an individual, it says he, because back before political correctness, he would have been a gender neutral kind of any person reference. And the other thing is that they were allowed to demand name, address, and an explanation of actions, whereas now in the later version, they're able to demand the name, address, date of birth, and an explanation of the individual's actions. So that is a minor change, and there you go. Now, James believes, or doesn't believe, I should say, that the officer had reasonable suspicion. So let's see what happens. I mean, this is from James Freeman's video, so he had to have heard this, right? Let's see what the officer says.
Over here.
Yep.
Okay. That's somebody called me that saw you parked here, I guess, last night.
Somebody called me that saw you parked here last night. Okay, well, where is here? Here is Hiram, Utah. Hiram, Utah. And what is this building here? That building there is the backside of this brick building here. I don't know exactly where it is, but it's going to be, Heinze is going to be parked somewhere right in here. And this is the Hiram City Power and Light, Hiram Library, Hiram Justice Court, Hiram City Museum, Hiram Museum Cabin Candy Store, Hiram City Fire Department, Cache County Ambulance. This is a governmental building complex. That's what this is. So he's parked in the parking lot of a governmental building compound, right? So why might that give the officer reasonable suspicion? Well, maybe there's an ordinance on camping because somebody saw him parked there last night. Well, or maybe there is a city ordinance on loitering or trespassing on public property. It is unlawful for any person to loiter or trespass during non-business hours, as herein defined, upon the public property owned by Hiram City, including city offices, the library building, park, cemetery, and surrounding properties adjacent to public buildings owned by the city, unless such person is on the property for lawful business purposes, i.e. to attend meetings that may be scheduled by city officials or other authorized persons having business in the building or upon the property. And it, of course, lists the any other property that comes under the jurisdiction of the city. So that's the fire station, North First West and 83rd West. No, so it's a different fire station. So anyway, so it is apparently against the law for a person to be on that property overnight, because that would be non-business hours, right? And that would be loitering. No person shall trespass upon public properties in the hours of 7 p.m. daily until regular business hours of the next business day, or on Saturdays, Sundays, or legal holidays, with the exception of the power plant park up Blacksmith Fork Canyon. I don't know where that is. The city square picnic areas, and where reservations may be made. So you could be in the park apparently after 7 p.m. daily, but you can't be in the parking lot. So the officer had reasonable suspicion that Travis Heinze was loitering or trespassing, and so therefore he had the right to demand ID, the name, address, and explanation of his actions. Okay? Now, this says that he pulled a gun. I don't know if that's particularly the issue that Freeman had, because I don't see him pulling the gun, but he does pull the gun in here.
Here, I can
As long as
pull
you
it
don't
out.
have any
Man,
weapons,
see,
you're
no,
going to pull a weapon on us, you're going to get one
go
pulled
ahead,
on
go
you.
ahead.
So I don't think that's too cool. If you're going to pull a weapon, you're going to get one pulled on you, and then the officer pulls a weapon before Heinze pulls a weapon. So I don't think that's pretty cool, but your mileage may vary. Now, the other thing that I've had a lot of people ask me to review is Travis Heinze, the video of his arrest from Natchitoches, Louisiana. I'm probably horribly mispronouncing Natchitoches, but there you go. And the first thing that I want to point out is that, and everybody is aware of this, that officers are allowed by law to demand identification for someone that they reasonably suspect has committed, or is about to commit an offense. Now, again, see Terry v. Ohio, see Illinois v. Wardlow. That is a super low bar. And another thing that I want to point out is that all of these recordings, including Travis Heinze's own recordings, start. See this? I'm at the beginning. There's the officers coming. They start with the officers in there. They start with him talking to the officers. In media res. What happened before the officers got there? Well, what happened before the officers got there is that concerned library staff called and reported a patron who was behaving bizarrely. This involved carrying multiple bulky bags into the building, setting up multiple cameras for recording purposes, trying to access areas restricted to the public, and pulling on door handles to areas that are off limits. This is from the Natchitoches Parish Journal. And an earlier article from January 27th describes the same actions. So, would someone who's behaving bizarrely, who's bringing in multiple bulky bags into the building, who's setting up multiple cameras for recording purposes, and who's trying to access areas that are restricted to the public and pulling on door handles that are to areas that are off limits, does that rise to the level of reasonable suspicion? I would suggest to you that it does. I think a judge would find that that kind of behavior is those particular actions, those articulable facts, would lead a reasonable person to believe that crime may be afoot. You can reasonably suspect crime is afoot. And as you can see, the judge found that must have found that there was reasonable suspicion in order to sentence him to 30 days, because resisting an officer is refusal by the arrested party to give his name and identity known to the arresting or detaining officer, or providing false information regarding the identity of such party to the officer. So that they must have found that he refused to provide his identity to the detaining officer, which means that the officer must have reasonably suspected, reasonably suspected that Heinze was committing, had committed, or was about to commit an offense, i.e. a crime. So there you go. There's 2 Travis Heinze stories in one. Just every time you hear James Freeman go on about there's no reasonable suspicion, listen to the cop. He hasn't stated any reasonable suspicion. Every time you hear James Freeman go on about that, just automatically understand that the officer does not have to explain his reasonable suspicion to the detained party, and officers can lie to the detained party. Because I believe that in this video, he asks the officer if he's detained, and the officer says no. So he's like, okay, well, then I'm going to leave. And the officer's like, wait, you're detained. So officers can and do lie, and you just have to accept that. The only thing that matters is what comes out in court. And if Travis Heinze believes that he was that his rights were violated, he should have sued. He had a couple years to sue, at least for federal law. I don't know about Louisiana law, but whatever Louisiana's personal injury statute of limitations was the time that he had to sue for a violation of his rights under color of law, 42 U.S.C. 1983. He did not do so. Now, we know that Travis Heinze is capable of suing because he has sued in the past for wrongful detention, and he apparently won something like $40,000 or $41,000. So, I mean, it can happen. And if you're going to ask me why a dude who won $40,000 is living out of his car, I don't know. But, you know, Travis Heinze is a special kind of guy. Thanks for watching. Have a great day.